Thanks everyone for joining this panel on the regulatory outlook for crypto assets. We have two of the world's leading experts on that here with me. And I'll leave it to them to introduce themselves, maybe starting with Karen.
Great. Hi, everyone. Karen Ubel. I am a partner in Goodwin's San Francisco office. I work primarily with investors and issuers in this space on the general corporate mechanics of getting projects up and running, but also the regulatory elements of designing a project, moving it towards launch, distributing a token, and all of the other elements and factors that go with that. I previously worked at the SEC for 6 years, so really kind of bringing a securities law background to these conversations, but love working closely with projects as they think about the regulatory challenges and getting towards launch.
Well, and hi, everybody. I'm Brian Brooks. Appreciate the opportunity to chat with all of you today. I was the acting controller of the currency in the U.S. government for the last 9 or 10 months, and before that was the chief legal officer of Coinbase. I now advise crypto hedge funds. I sit on the board of a number of blockchain and crypto companies, and we'll have a bigger announcement to come in the next couple of weeks. So look forward to the conversation.
Awesome. Let's go ahead and start with the first question for Brian. So you wrote an article in the Financial Times about, get ready for self-driving banks, where you compared DeFi to autonomous vehicles. And in that article, you described some of the changes that regulators can make to adapt to that new world. And I guess basically the question is, could you help our audience envision that? What would that look like? And what would it take to get there, both from the regulator standpoint, but also from the perspective of the crypto ecosystem?
Yeah, well, look, that's a great question, and obviously I wrote that for a reason, which is I think that DeFi, is one of the actual killer apps of crypto. And if you think of crypto as essentially an attempt to build networks for the transmission of value in all kinds of different ways, it will only be successful when people don't need the traditional banking system anymore. And so what that would look like, presumably, is algorithmic banking. It would be a mature version of the compounds and makers and uniswaps that we all see today. So the point I made in the article was that if you look at what banking regulation has historically been about, it's mostly not actually about regulating banks or banking activity. It's about regulating bankers, right? So all of the risk management rules that the regulators impose, all the licensing rules, all the supervision rules, it's all about making sure that there's no bad guy inside of an institution who's committing fraud or acting negligently or skimming from the till or committing discrimination. That's really what it's all about. But it's not about the underlying process of allocating credit or administering loans or taking deposits or anything else. And so if you think about what DeFi is all about, it's about running the functions of a bank without the people, right? It's open source software instead of human beings allocating credit and doing all of the other things that banks do. So the question was, how should we think about that from a regulatory perspective? Is it a good thing or is it a bad thing? And the answer is a little bit of both, right? It's a bad thing in that we do not have a regulatory framework set up to capture activities. It's more to capture people. But on the other hand, it's a good thing because many of the risks that are present in the existing financial system are about human fallibility, not about the underlying technology. And so in a DeFi world where algorithms can do everything that banks do, powered by crypto tokens, that seems to me to solve a lot of regulatory issues. What we need to do, however, is create public confidence in them by saying, hey, look, this software is safe. We've looked at it. It's not lying to you. It's not attempting to steal. It's not like in the movie Office Space where it's stealing a quarter of a penny of every transaction and making it up on volume. It's a legitimate allocator of capital, much like a bank is. And so the theory was, what if we started granting charters to software as opposed to granting charters to groups of people? That's kind of the vision of the future. A lot of work to get there, but I think it's probably a worthy objective.
Awesome. That makes sense. So the next question I have is for Karen. So the vision of the future Brian described, it sounds really awesome. How would you describe the reality of the crypto ecosystem today from a regulatory standpoint? What sort of problems are founders facing on a daily basis?
Yeah, unfortunately, I think Brian has identified this world in the future that I think has adapted to the technology and embraced the technology. Where we are now is unfortunately very far from that. A lot of what we're doing with regulation is trying to fit a square peg into a round hole It's applying 1936 case law to something that certainly was never contemplated. And I think that the result is a framework that many entrepreneurs and investors describe as relatively frustrating, haphazard, siloed. And I think it's really causing a lot of problems and challenges because people really want to comply. I mean, if there was a regulatory framework that was feasible and workable, the majority of the folks that I work with would happily embrace that and move through that compliance framework. Unfortunately, it just hasn't been a place where we found any sort of mechanisms that make concessions to the technology without kind of just applying the regulatory regime as it currently exists. And it's particularly frustrating because we're actually now, really, while this technology is still very nascent, we are now about 5 years out from the Dow report. We're 4+ years out from Commissioner Clayton at the time, really kind of making some broad statements about, tokens being securities. And I think we were hopeful that there would be more movement from regulators to create a system that could work better for these projects to continue to innovate. We just haven't seen that. And then even more challenging, I think, is a world where we're now we have to, in all different regulatory regimes, including the securities law regimes, where we're working on a concept of using analogies to try and create a potential compliant framework. But I think in some of the enforcement actions, number one, we're seeing the idea that with the recent case brought against Ripple, it could happen anytime in your timeline, even after you think that you've really kind of, made it past some of the regulatory scrutiny. And in addition to that, in Telegram and other cases, we saw, kind of a weird application or kind of ignoring some existing securities law principles like Rule 144. Commissioner Peirce commented in I think she was asked the question in her previous presentation today, is there a different standard, or is crypto held to a different standard? And it feels that way, that even if we try to kind of fit in the existing regulatory frameworks, we're getting a different interpretation of things that are longstanding, longstanding frameworks like Rule 144, for example, things like that are now being applied in a very different way. So I think that it's really the challenge here is that there's just not a way to make this. To basically work within the existing framework as we're kind of being told by regulators that we would need to do, in a way that actually allows the innovation to thrive. We don't have a mechanism whereby the securities laws are T+2 settlement, and that simply doesn't work, as you know. When we have broker dealers and intermediaries, the exact things that many of these technologies are working to disintermediate and really kind of innovate around, you're kind of being pushed back into that very same regulatory framework and structure. So I think we're still in the same place, unfortunately, that we've been for a long time, which is a gray area that makes it very difficult to advise both investors and investors and projects on what might be the compliant path forward. And given the market conditions, a lot of folks are really continuing to push ahead. And what we can do is mitigate risks and create guardrails. But unfortunately, we just don't have any clarity on whether that will be enough to keep you out of kind of the spotlight of regulators.
Got it. And I think you've at one point described, the regulatory approach towards crypto today as sort of, regulation by enforcement. Could you describe a bit for the audience, what exactly that means? Why is that problematic? Do you see any path towards that, changing at some point in the future? I'd love to hear more of your thoughts on that.
Yeah, regulation by enforcement is really not particularly productive because rather than having a principles-based, forward-looking guidance system that everybody could say, okay, how is this going to apply to my particular facts and circumstances, which is what we have in the securities laws with materiality and different concepts like that that allow for you to take a principle of the securities laws and apply it down to your facts and circumstances and figure out what the right compliance mechanism is. With regulation and by enforcement, there are a number of challenges. Number one, we have no idea, the number of cases that were investigated and not brought. Wouldn't that be wonderful to know why those things weren't brought? Wouldn't that be helpful? But we don't know. We only know the cases that the SEC settled or filed a complaint against. And what we're left with is trying to kind of parse through the arguments that the SEC has made, or in certain cases like Telegram and Kik, that the court has included in their opinion and their ruling. But the challenge is, of course, that all of those are fact specific, and a number of projects, every single project can find a way that their facts or circumstances might be different than those that are in the Telegram or Kik case or settlements that we've seen or things like that. So it's really difficult for us to draw any sort of broad-based conclusions when you're using something like enforcement that is very much a fact-specific case. And so we've heard from enforcement staff that there is an arc that we should be interpreting on, why are they bringing the cases that they're bringing? But I've worked with a lot of different folks and talked to a lot of different professionals in the industry, and it's very hard for me to see what that arc is and where it's leading us to. We're able to parse some particular lessons, but it's also not being necessarily applied evenly or equally. And in particular, it creates a world where, projects can point to, hey, I just want to do what they're doing. They're doing it successfully. It doesn't look like they're having any challenges. We don't know if they're under investigation. We don't know if they might be, subject to investigation in 2 years' time. And so I'm worried that once again, much like what happened in 2017, where there were a number of ICOs, and it wasn't until pretty far into that that cycle that we got some guidance and some enforcement actions from the SEC. I worry that the same thing might be happening here again with DeFi, is that this is proliferating. There's a lot of exuberance, and there's no guidance that's available. So will it simply be enforcement action that then comes out and somehow cast doubt on the entire industry as a whole, even as a number of projects are doing things that are exciting and innovative, and there's no fraud, there's no bad actors. It's just you're not complying with the framework that the SEC may be thinking about but not communicating to us. So I think that's really the challenge, is that we just don't know whether or not projects have been investigated and gotten a thumbs up. We don't know if they've talked to the SEC, and people are kind of pointing at models to try and follow, and it's really hard to give that guidance without knowing what's really going on and having some perspective, principles-based framework to work within.
So
Got it.
Hey, Joey, maybe I can just jump in and provide a slightly different perspective, which is, first of all, let's zoom out. And so there's the world of securities regulation, and of course the SEC is principally an enforcement agency, so that's kind of what you get out of the SEC. But then there's a whole lot of other stuff going on here, and when I look back at the regulatory developments of the last 12 months, most of it either came out of the bank regulators, or it came out of the President's Working Group on Financial Markets, which I think did actually provide for the first time some actual sort of regulatory zone of operation for the industry. So just to recap for people who didn't pay attention over that period of time, obviously at my agency, we did 4 important things in a fairly short amount of time. So first of all, we opened with the concept of stablecoin activities for banks. We then moved on to the concept of, so that was about custody for stablecoins. We then moved on to the idea that that there were a series of direct blockchain connectivity that banks could engage in, including like being validator nodes on blockchain networks. So imagine like being a Bitcoin miner or an ETH, node to support these payment networks. And of course we provided some other interpretive letters along those lines. And then at the end, we began chartering crypto banks with a clear risk management framework and capital standard that allows companies like Anchorage and Protego, and here I'm going to tease a little bit, but shortly a couple of others, to come into the national banking system. So I think those things are important. And then on the heels of that, the President's Working Group on Financial Markets, which is an interagency group led by the Treasury Department, but which includes the CFTC, the SEC, the OCC, and the who did I forget? One or two other agencies, came out with some further clarification about crypto generally and stablecoins in particular, and set forth some requirements that the government would regard as compliant. So I guess my first message is the world is not just the SEC. There's a lot of other stuff going on out there, and the problem with the SEC, which I sort of echo, is they take a taxonomic approach to this stuff, which is, as we all know, not really what crypto's about. Crypto's not about whether this token or that token has certain investment characteristics. These tokens are designed to power underlying networks that do a lot of cool stuff, because we're trying to build the internet here, And when you think about it like that, I think what the broader group of federal agencies has done is really important. So I would say that. But then the other thing I'd say on the SEC, which is probably the proudest thing that I worked on at Coinbase, was putting together the Crypto Rating Council, which, in the absence of clarity from the SEC, was basically a self-help organization that put together a repeatable process for kind of risk assessing various tokens in terms of their likely securities compliance. And I would just note that, the SEC has not filed suit against any project that had a 4 or lower rating on the Crypto Rating Council's metric. They've gone after what the CRC said were high-risk tokens to begin with, which suggests, at least at some level, that that's a reasonable way of managing risk, which is to tell the world, this is the way we think about securities risk, even if the SEC won't tell us how they think about it except through enforcement. And as the more we do of this and the more investors rely on this, the less likely it is that the safer tokens on the safer side of that spectrum are going to have risk in them at the end of the day. So I think getting more buy-in to those kinds of, I don't want to call it a self-regulatory organization, but think about it as kind of like the MPAA for movies. The more of that we have, the less the SEC will feel the need to enforce, because they'll see some amount of self-policing by the industry.
I would certainly agree just as to that, I think certainly my background is SEC, and I think in the past we have seen the SEC be a little bit of the elephant in the room and the focus for crypto projects. But I would agree, Brian rightly points out that there are a number of other initiatives in other elements of the crypto ecosystem that have had more prospective guidance. And I do think also, I expect, I think some of the new trends that we're seeing with blockchain technologies like DeFi, I do actually expect that some of these other regulators that have been a little bit more prospective, I think will also be a little bit more active and a little bit more dominant, given I think some of the features of these new technologies. So I agree that I think that's promising in some ways, that a lot of the folks that Brian mentions have a little bit more of a history of being more prospective, and hopefully that could promise a little bit more of a more certain landscape for some of these new projects.
Thanks for that. That was helpful a lot from both of you guys. The next question that I have, this is a question we get a lot at Pantera as well, which is, over the past year, there's been things published both by FinCEN and also the Financial Action Task Force that have sparked a lot of controversy within the cryptocurrency space surrounding different proposed reporting rules and guidance. Could you guys give us an overview of these proposals, what problems they're intended to address, and then I guess, why they either don't address those problems in the right way, or why they receive so much backlash?
Well, so I'm happy to sort of just kick off and say a little bit of what they do. So the first thing is, let's just talk about what FATF is. So some of you may remember, this was a long time ago, but you may remember back when we lived in a democracy and like the laws were enacted by people that people voted for and had some kind of political accountability. It was a super long time ago that was true, but I seem to kind of remember something about that. FATF is a global treaty organization, essentially consisting of the G20 nations plus or minus, 1 or 2. But it's a group of kind of mid-level bureaucrats, so not elected officials and not even politically appointed and Senate confirmed officials, who gather in these rooms and they come up with this guidance document. But pursuant to treaty, the countries who are signatories to the FATF treaty have more or less agreed that when the FATF adopts certain guidelines, that they will use best efforts to enact them into law in their home countries. So basically, if FATF decrees something, if these people you've never heard of and you never voted for decree something, then the U.S. government, is obligated at some level to either enact those rules or face, sort of sanctions in the financial system. So that's what it's all about. And FATF has really done a couple of things attempting to render crypto banking, right? So the problems that crypto people thought they were trying to solve, FATF's a little bit trying to prevent you from solving them by saying, no, you can do all this cool stuff, but it still has to be a bank. It still has to act like a bank. So the first thing FATF did a couple of years ago-ish was they promulgated amendments to what is called the travel rule. Most of the people on this call are going to know what that is, but that's a rule that applies in the world of bank wire transfers, where when a bank, when Bank A sends money on your behalf to Bank B, it has to append to the instructions, because remember, that's what like SWIFT is. It's just a messaging service. It says, hey, send $100 to this account, and by the way, the sender is Joey. Okay, now it's Brian's account, and when Brian then sends it on to Paul, it says, hey, Brian is now sending to Paul, and that send receive information has to be appended in the message so that anybody can see that, so law enforcement or any regulator can see that. That's, of course, a little bit anathema in the world of crypto, right? Because our whole point is true peer-to-peer. We don't want there to be intermediaries who are appending a bunch of information. We want to be able to send it directly from Brian to Joey. We don't want to message the bank to send the money to Joey. I want to just send the money to Joey, right? That's what crypto is all about. So some of this is a little bit countercultural in the crypto universe. Fast forward a year, and now you have the new FATF guidance, which is this is the really disturbing part. This is where they've decided that not only are, they use this ridiculous term VASP, but basically that means an exchange. So not only are exchanges required to be like a bank and append this information to their send-receive transactions, but if you're a DeFi protocol and you've created, right, DeFi, which we just talked about, so now there's a software out there that you're not operating. It's just something that some coders wrote, and maybe it's open source and whatever, and it's out there doing things. What they're now saying is that software must do what I just described, and if it doesn't, then you, the coder who built it last year, are liable for that, right? So it basically defines a coder or a company that launched a DeFi protocol or whatever as a VASP for purposes of guaranteeing that travel rule compliance. That's a little bit scary. The analogy is, for those of you who follow the analogy, it's a little bit like the way the Bank Holding Company Act works in traditional finance, which is it says, okay, you're just an investor. You're not a bank. You're not running a bank. You're not on the board of a bank. But if you own more than 9.9% of a bank, you're subject to all the limitations that come with being a bank. And that's why private investors mostly don't want to invest in banks, because they don't want to be treated like they are a bank. Same thing here. You thought you were a software engineer, but you're actually a VASP. So this is something that has significant negative potential for DeFi protocols. Not clear how a U.S. court would interpret this if, in fact, the U.S. adopted this as a regulation, because normally we don't hold people liable for conduct they didn't do. But this is a crazy world we live in. So let me just pause there, and that would be my quick summary of it.
Awesome. And well, actually not awesome. It's an awesome summary, but it doesn't sound like a great.
Awesome. I didn't describe it very well.
Yeah. It's so I guess, yeah. So how do you think about this? Like, if something like this did go through, this is for both you and Karen, how would projects even potentially comply with this in practice? What does that world look like?
Karen, you want to hazard a guess?
Gosh, yeah, I think it's going to be very difficult to comply with this, and I think it's going to be very challenging. I certainly think, right now, again, as Brian points out, the idea is that making software available that can be used in any number of ways by any number of people, it should not impose upon those software developers these kinds of obligations, and I just I think it could be a real killer for a lot of the innovation that's happening in this space. I wonder though if there is room in some ways where we talk about kind of a little bit of regulatory arbitrage, but in some ways whether moving towards calling these things a security or some other thing, and actually embracing a different regulatory regime could move you out of a particular set of application of certain laws like these FATF or FinCEN rules. But are you trading one devil for the other? Who knows? But I think that maybe that's something that might be explored if we can find a regulatory regime that would potentially allow, could supersede this, but would also come with its own challenges, I'm sure.
Well, here's the great news. So while we've been sitting here, I just saw a sort of a provocative headline that came across in a related area. So this might be the good news. So the headline says, let me see if I can read the headline. It says, artificial intelligence cannot be named inventor on patent application, judge says. So what's interesting about that is, if you think about the way that this FATF thing applies to open source software DeFi algorithms, it would seem to be the same kind of thing. So you've got an artificial intelligence program that you've set loose on the world. The artificial intelligence comes up with a new business process of doing something, and a judge says, no, the artificial intelligence platform, that can't be treated like a human being for purposes of owning a patent or being liable for infringement or whatever. You might argue by analogy that that's very similar to this FATF concept with DeFi. That's a piece of software. It's not a human being. What it's doing on its own. It's open source, and many people have the ability to go and change the code and all of that other stuff. Ergo, it can't be subject to those requirements. I mean, maybe that's the good news. So I think we're in this brave new world of computers doing what human beings used to do. That's kind of an interesting headline, Joey. Maybe we can follow that one up.
It does sound interesting. I think the other thing that's interesting, is it possible, does the U.S. have to, follow like the FATF guidance? Like I know it's other things like the World Trade Organization, the U.S. hasn't always, followed what they said. Is that a possibility as well? Like, I guess the other question is like, does this have to go through Congress, or is it something that a regulator does? How does this get implemented on the U.S. side?
So regrettably, it's unlikely that if the FATF were to finalize something, that the U.S. wouldn't do something about it in some way, especially because the U.S. if I've got this right, I think shares the chairmanship of the FATF this year. So it would only get adopted by U.S. assent on the front end. What would normally happen is that if it gets enacted, and the whole U.S. membership in FATF is run out of the Treasury Department. Janet Yellen, obviously no fan of crypto, as you know from her public statements. And so the idea that she would somehow kibosh a rule writing exercise inside of FinCEN to adopt this as a US regulation seems to me pretty far-fetched. And as I say, there are some consequences if a country fails to use best efforts to respond to a FATF pronouncement in some way. So I would say it's not something we can ignore. It doesn't have to go through Congress, and we have a Treasury Secretary who's relatively hostile to crypto at the moment. So the best hope is to influence what it winds up saying and to slow it down. That's the best hope.
Got it. That makes sense. So the next question I had is, we spoke to SEC Commissioner Pierce earlier today. She has talked a lot about, a safe harbor for projects issuing tokens. It doesn't seem like that's likely, but if that did happen, what would a safe harbor look like, especially for Karen? How would that change things for your clients compared to, what their options are today?
Yeah, I think a safe harbor to me is a really interesting idea, because what we've heard a lot from the regulators, particularly from the SEC, is a focus on information asymmetry as being problematic. And so if disclosure is what they're really after, I think that there's a world, and Commissioner Pierce's framework proposes this. There's a world where we find the right disclosures and make that part of the process, if that's what everybody is really interested in and focused on, so long as it doesn't turn the underlying token or the underlying blockchain or the underlying technology into a security itself and require that it now has to kind of comply with all of the securities laws requirements. So I actually think that there is some level of disclosure that the majority of the folks that I work with would be willing to provide, even if I don't think that the current disclosure regime and the disclosure requirements are necessarily the right regime or the right categories of information for a crypto or blockchain focused project or the sponsor of that project. But I think that even so, I think if that were the, a path to clarity, I think that most clients would say, sure, I'll put some exec comp disclosures down on paper and provide those to, in some sort of a framework or, financial statements, things like that. I think it would be great to work with regulators to figure out what the right kinds of disclosures are. But I think that there certainly is a world where if that's what we're really focused on, and that is actually what is consistent with the SEC's mandate, then I think that without question, there's a world that we can get to where clients would be fine with that kind of a safe harbor if it allowed for the token to continue to be freely tradable and the innovation to continue in this space. And I think that it would be great, something that I think that regulators really should be thinking about, because I think it allows for the innovation to continue to happen and really supporting the kind of, as Brian and others have described it, the new age of the internet, the new phase of the internet, and all of the things that could bring with it. And we're already seeing and exploring. I do think, though, we have seen that the SEC has accepted the idea in various ways of this concept of something could kind of be sold as a security, meaning that the way that it's offered and sold could be a security, and then later could no longer, it could be deemed to have different facts and circumstances so that the offer and sale is not a security. I think getting some more clarity on that would be helpful, but I do think we've seen that in a number of different contexts. Whether it be with Blockstack and using the Reg A framework, and then later just recently being able to kind of submit some analysis and facts and saying we're no longer responsible for the success or failure of this project, therefore we are no longer offering or selling a security. So those kind of things, those kind of frameworks, I think are really interesting, but I think certainly would be embraced, and I think disclosure is certainly not an impediment or a hurdle that most projects would not be willing to consider. Again, it may be focusing on the wrong things, because who is providing disclosures and what are they disclosing? It may not be the things that are actually relevant. So I think there's some work to be done there. But I certainly think a safe harbor would be welcome in the industry. And I think that there's a lot of folks that would be interested in working with the staff and other regulators to figure out what the right framework for that is and what the right disclosures are, if that's what the focus really is, and as I think it should be.
Got it. I have a question for Brian as well. It's kind of related. If you look at one topic that's been in the news a lot recently, it's Section 230. Which gave internet companies a safe harbor for the speech that their users put on their platforms. Obviously, that's part of the reason why the internet has gotten so popular. Do you think it makes sense to have something similar for DeFi? What are your thoughts on that?
Well, I would argue that it makes a lot more sense for DeFi than it does for social media companies, for obvious reasons. It seems to me, right? The concept of Section 230 was supposed to be that if you're running a passive, bulletin board, a place where people come and they do what they do, and all you're doing is providing a technology platform, then you should be insulated from the negative implications of whatever those people are doing, because you're not the one speaking, right? If I host a platform and you guys want to say a bunch of hate speech, or you want to advocate for things I don't agree with or whatever, it's not my problem, because you're the ones talking and I'm just creating technology. The problem comes in when the platforms say, wait a minute, I don't like what you're saying, and I'm going to make a values-based judgment that you should be deplatformed or have a trigger warning or whatever, and that's the controversy around Section 230. The promise of decentralization is there literally is no human being making these decisions, right? This is all peer-to-peer. That's how it's better than banking. There's nobody to shut off your checking account. There's nobody to say, I will not process a payment because I don't like who your recipient is. The idea that the credit card companies at one time said they won't let you buy a hunting rifle with the credit card because they think guns are bad for America. I mean, it's your money. and those things aren't illegal. Like, how do you think about that? So to me, the concept of a Section 230 concept makes way more money, or way more sense rather, in a decentralized environment than it does in a centrally managed environment. And let's be honest, Facebook and Twitter are not decentralized. They are headed by an executive management team that embed their values into what they do every day. And so why those guys get a free pass isn't obvious. But when it's DeFi, there is no Mark Zuckerberg, there is no Jack Dorsey, it's just open source software. And so it makes a lot more sense to say that's a safe zone because it's just the public interacting with each other. Software is different from human decision making.
Got it. The next question is for both of you. One thing entrepreneurs often hear from regulators is regulators love to say, come talk to us. What is your perspective on that advice? Brian, you've been on both sides of the table. Karen, you represent a lot of folks. I'd love to hear what your thoughts are on that advice and how that actually plays out.
Shall I start? I've been on both sides of the table too. I mean, I was at the SEC for 6 years. And I have to say, we did this a lot when I was at the SEC. I was in an office that handled all of the weird, unique, strange, and novel things. And we had a lot of these conversations that I imagine are very similar to the ones that are happening now in FinHub. The challenge that I have seen, and I've expressed this to my former colleagues, is that in the days that I was there, people would come in and it would really be a true conversation, a give and take and a back and forth. My experience lately is that just hasn't been the structure. It's a lot of information gathering by the regulators and not necessarily a back and forth or a real discourse. And I think that that's what's missing. And therefore, without having that, you're taking the risk that all you're doing is kind of putting yourself on their radar screen and not getting any real benefit or value from that give and take. And so I think that's what, I think it's very hard for me actually to necessarily recommend that to clients without knowing that it really is going to be something where we feel like we can learn something from the conversation, something that we can implement, as opposed to right now, what I often feel like is that it's a little bit of a, well, did somebody smile? Did they nod? Were they listening? Were they engaged? And I think that's such an interpretive dance that is not necessarily providing meaningful feedback. And I'd be hopeful that there are ways and mechanisms to have a little bit more of a productive conversation. Like I said, I think we haven't really seen a lot coming out of CorpFin. The April 2019 guidance was the last that we've seen, and some limited no action letters. So it's difficult to say that that's necessarily a productive path. But Brian, interested in your thoughts.
Yeah, I mean, look, I think more engagement is always better than less engagement. I think people who approach a government agency expecting that they're coming to ask questions and they're going to get answers from the government agency are usually disappointed, because generally speaking, for a government agency to authoritatively give an answer to anything involves some amount of process. So, if you come to the OCC asking whether you're going to get a bank charter, or if you go to the SEC asking if this token is a security or not, they're probably not going to tell you, because they probably can't tell you. Even if they said something, that's not the view of the agency, it's just the view of the person you're talking to. So I think that's an issue. Having said that, though, the likelihood that you're going to be on the receiving end of an enforcement action generally goes down the more engagement you've done, because you start to get a sense of at least what questions are they asking, what's their concern level, and that's all good. And then the last thing I guess I would say, and it remains to be seen how this is going to play out, but if you look at Ripple's defense to their SEC lawsuit, a big part of their defense is, hey, we and multiple exchanges came in and told you what we were doing and asked, and you didn't say that this was a violation when we gave you the chance to. So whatever else you can do to us, you can't accuse us of a willful violation, because we did try. Now, it remains to be seen how that's going to be received in court. But my basic view is there's a huge difference between a bankrupting or license revoking proceeding based on an intentional violation and a negligence violation where you did your best, you got it wrong, but you certainly didn't do it through subterfuge or fraud, right? You were open with the agency about what you're doing. I think at the end of the day, that's likely to be a relevant fact. And so for no other reason, that would be a reason to want to engage pretty openly with your regulator.
Got it. So
I think,
it's
well,
time to,
just-
it's,
sorry. I was going to
I
say
was gonna say-
one quick thing though is I do think though Brian mentioned the CRC, and I do think that there's a lot of room there, and I wish that there would be a little bit more openness to industry groups coming in without a specific client. I think it takes away, we're able to present some of those risks and have some of those conversations without necessarily the taking on the risk of being an enforcement target. So sorry Joey.
Awesome. Yeah, I was going to say we're about out of time. I think for the last kind of question, you guys each have about 50 seconds. It's a two-part. So one is kind of what's your outlook or overview of the regulatory environment in the crypto space for the next year or two? And then the most popular audience question is, Ray Dalio thinks Bitcoin is going to be banned. Do you think that's feasible?
Well, I'll just give you my very quick 2 cents on those things. I think that the good and the bad thing about a $2 trillion crypto market is it's too big to be killed. So that's the good news. The bad news is it's big enough to be noticed. And so it means that the level of sophistication people are going to have to bring is going to have to be higher. That'd be my quick answer there. I guess I've sort of answered your second question. I don't think Bitcoin can be banned. I mean, you can't ban it. I mean, think about Casablanca, right? The Nazis tried to ban Victor Laszlo. At the end of the day, freedom wants to be free. You cannot ban these things. You can drive them underground for a period of time, but it's like when people tried to ban Uber, and a lot of governments tried to ban Uber. That's just not the way that it works when people want something.
I agree. I don't think Bitcoin is going to be banned. I don't think crypto is going to be banned. I think one of the big telltale signs I think that's been really interesting to me is I think in 2020 and 2021 we've seen a lot of really successful launches of large scale projects that I think were in the works for a long time. And I think that having all regulators and legislators actually see some of these projects come to fruition in a way that actually really demonstrates tangibly the power of the innovation and not just the prospect of the innovation. I think we're seeing more and more of that. And I think that gives us more tangible things when we go in to talk to those folks to point to really, to give them more basis to say this isn't something that, we need to stand in the way of as just, a way to, finance terrorism and buy drugs. This is real innovation with real users, and I'm really excited to see more and more of that. And I think it gives us a lot, as an industry, a lot stronger legs to stand on. And I think that'll really support the future of this industry.